May it please the court, Your Honor, opposing counsel, members of the jury. A death is not always a murder. An accident is not always a crime. Fact, the curb near 5234 Canyon Road is very dangerous. There have been multiple accidents at this location. There was no guardrail where the vehicle left the road. There was a large group of trees that lie next to the road within the danger zone. Fact, by all accounts, there was a heavy rainstorm that evening. The roads were slippery and the visibility low. Fact, out of all the evidence in this case, there was only one single swerve. Members of the jury, given these facts, we want you to remember the 3 Ds. 1, dangerous curve. 2, downpour. And 3, deer in the road. The 3 Ds equals doubt. Reasonable doubt. Given the 3 Ds, this car accident could have happened to anyone. Members of the jury, in our culture today of the 24-hour news cycle, CNN, headline news, True TV, we are quick to judge, quick to blame. Someone must always be responsible, regardless of the facts. But the simple truth is this: a death is not always a murder. An accident is not always someone's fault. The state of Midlands has the burden of proof in today's case. They must prove beyond all reasonable doubt that Danny Dawson committed murder and driving under the influence in the state of Midlands. Now, this is a very, very hard burden. Very hard to prove. Members of the jury, in the state of Midlands, to be charged with a criminal offense, a person must be arrested by a police officer and charged by that arresting officer. The state of Midlands are so confident in their case against Ms. Dawson, they did not bring the arresting police officer to testify before you in this court. Members of the jury, the state of Midlands, to attempt to prove these charges, called 3 witnesses. They first called London Bennett to the stand. London Bennett indeed did witness the car accident that evening, but by his own testimony, London Bennett was not a Chinese law. London Bennett did not observe Ms. Dawson at any point during this evening. London Bennett confirmed Canyon Road is very dangerous. London Bennett confirmed there are not only an abundance of deer, but possibly lice. Members of the jury, as the defense, we call to the stand Leslie Roman. Leslie Roman is an expert accident reconstructionist. And by his conclusion, that white 2009 Chevrolet Impala swerved to an avoided object. Again, in almost 20 minutes of travel, there was only one swerve. Leslie Roman, too, told you Canyon Road is very dangerous, and these conditions alone make it possible for an accident to happen. Leslie Roman testified that he has conducted expert accident reconstructions when the drivers of the vehicle have been under the influence of alcohol, and not all the time do they drive recklessly or unsafe. The state of Midlands called to the stand Avery Smith. Now, Avery Smith is the director of the Department of Forensics in the state of Midlands. Avery Smith is the author and certified trainer in breathalyzer tests in the state of Midlands. Yet Avery Smith, by his own testimony, did not observe the required 15-minute pre-observation period. Avery Smith admitted through his testimony that if a factor occurred during that period and skewed the results to a breathalyzer test, those results would be invalid. Avery Smith gave his testimony that he conducted no other medical diagnosis. He tested for no alcohol-creating enzymes. He administered no blood tests. And he did not utilize the recognized formula for elimination rate in the human body to test how much alcohol is present within adults. The defense called to the stand to rebut this testimony Dr. Ashley Norton. Dr. Norton and Avery Smith agreed on one thing. They were both very surprised at the results of 0.19 that breathalyzer test gave. They had figured the results would be somewhere near 0.08, leaving only one conclusion to be. One of those factors must have indeed occurred and skewed the results of that breathalyzer test. Members of the jury, State of Midlands' last and final witness was the third friend in their group of friends, Taylor Hobson. Taylor Hobson admittedly was not regularly consuming alcohol. Taylor Hobson admittedly had one too many drinks. Taylor Hobson was drunk. Taylor Hobson left with Vanessa Solomon and Danny Dawson, walked right by a taxi cab and got into that vehicle. Members of the jury, Danny Dawson did the only prudent thing by you. She took the car keys away from two highly intoxicated friends. Danny Dawson drove down a wet, grainy road when was suddenly approached by a deer and swerved into a wooded object. Danny Dawson confirmed, and you could hear it on the voicemail the state played for you. As Vanessa seen that deer, she screamed. Members of the jury, car accidents with the loss of life are very tragic. The burden often carries a lifetime. But the simple truth is this: a death is not always equal to murder. An accident is not always a crime. The state of Midlands had to prove beyond all reasonable doubt that as a driver of that vehicle, Danny Dawson acted so extremely reckless, it manifested the indifference to the value of human life. The state of Midlands had to prove beyond all reasonable doubt that Danny Dawson was indeed under the influence of alcohol intoxication. Members of the jury, as I look at this roadway, I ask myself, how does a drunken driver, acting so extremely reckless, make it 20 minutes down the roadway, yet there is only one swerve? One swerve, one set of ruts, and there is only one